Orders of the day. Ordre du jour.
Government orders, government bills commons, government bills Senate, resuming debate at second reading of Bill S-7, Combating Terrorism Act.
Lorsque la Chambre
when the House last considered the bill before the House today, there was 11 minutes remaining for the member for Abitibi-Témiscamingue. So, resuming debate. The Honourable Member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. As you said, my time ran out on Monday, and when I was cut off, I was talking about the witnesses who had spoken out against this bill. And they considered it useless, that all at the same time was undermining people's civil rights and human rights. And this was when the Senate Human Rights and National Security Committee was studying this bill in its previous version in a previous parliament. I want to come back to what Mr. Denis Barrette said from the Coalition for International Civil Liberties was saying, and he said that the preventive arrests and other issues under this bill are dangerous and misleading. The debate of Parliament on this issue must really depend on a rational and enlightened debate on this legislation. The first provision allows for a person to appear before a judge when the judge feels that this person may have information regarding an terrorist act that will be committed or has been committed, and so this person can be incarcerated for a period of up to a year. The provision, moreover, gives the state new search powers of search and seizure, and there's not enough being talked about in this regard. This can prevent the person from tabling something before the judge or the court that they could give to the police, and moreover, this allows for racial profiling or that kind of discrimination on ideological or religious grounds. In its report in 2005, the UN Human Rights Committee spoke about its concerns with the excessive scope and some of the definitions in the terrorism legislation, and the committee said that the state should have a more specific definition of terrorist activities so that people are not targeted for religious, ideological, or political reasons. I think that here we can see that there are various problems that have been posed by C-17 at the time in the area of civil liberties, and I think that this is parallel probably in this bill. As I was saying earlier, in this bill, there is clearly a problem of balance between security and safety and fundamental rights. What concerns me is that I say no reason to justify the implementation of those provisions. How do these provisions, which have expired already now 5 years ago, how can they be so important that they need to be put back in again, while at the same time their usefulness was never proven? No witness could testify to any case that required this kind of legislation. These provisions are not necessary. On the contrary, witnesses said to the Senate committee that there were major problems in terms of human rights and children's rights with this legislation. And I'll come back to what Mr. Ishan Garden said from the Canadian or the American Islamic Relations Commission said. People are talking so much about this national security issues over the last 10 years. We are aware of the significant risks that are to our free society, but also that some of these reactions are excessive. We risk indeed to undermine some of the fundamental values that are at the very heart of Canadian society without at the same time protecting anyone against terrorists. If we want to try and strike a balance between human rights and security, that is really an insurmountable task. While sharing many of the concerns that others have spoken of in regard to this bill, Canadian Muslims certainly have certain fears, because this bill could have a disproportionate effect and be discriminatory towards our community. And this, knowing that there is an incidence on civil liberties, all of the major attempts that were made to carry out terrorist acts, like with the Toronto 18 case, there were provisions used like preventive arrest, for example. So once again, I'm saying this is another witness who said that the provisions of this bill are not necessary and could even reflect certain risks. If we come back to what Mr. James Kekin said, it would also be good to remember that those who choose to remain silent in this context are not necessarily guilty, and that the choice of choosing to remain silent is not an admission of guilt. For example,
people could have legitimate concerns for themselves, family members, or their community. There should be a mechanism as exceptional as investigative hearings only to prevent imminent terrorist acts. It should not be used to investigate past occurrences. But under this bill, investigative hearings could be held to look into past events. And the imperative of protecting innocent lives would be completely absent. Already we're seeing beefing up of powers, and we're already seeing some excesses when it comes to the use of authority. This bill would allow for arrest and detention without the need to prove that the allegations are well-founded. In fact, the individual freedom of certain people could be seriously restricted under this bill, even if those people were never convicted of any crime. Whoever refuses to accept, whoever refuses to enter into a recognizance could be detained for up to 12 months, and there's no limit to the number of times these provisions could be applied successively. This is hardly in keeping with our principles of our legal system in Canada. The fact that some people have been detained for up to 8 years under similar circumstances should worry us all. I think we need to think about something like this seriously before passing a bill such as this. When it comes to combating terrorism, it's not just a matter of adding teeth to the criminal code. We have to ask why. And because Canada already is a member of a number of international conventions, I don't think these measures are relevant or useful. When these were last discussed, the purpose of the Anti-Terrorism Act was to update Canadian legislation to meet international standards, including the requirements of the UN. All of the Anti-Terrorist Act and its provisions, excluding investigative hearings and recognizances with conditions, i.e. what we're discussing today and what we find in S-7, all of the other provisions of the Anti-Terrorism Act remain in force. To be more clear, all the original provisions of the Anti-Terrorism Act have remained in place except for the 2 clauses that expired in 2007, which had never been used, and which parliamentarians did not see fit to extend because they didn't find it useful. Now, the Conservative government opposite is saying that the NDP is against making Canada safer and against combating terrorism. But the truth is that this bill provides nothing more concrete for security, and it will affect the freedoms and individual rights of Canadians. And in my view, that's a bad thing. Canada already has sufficient legal tools to deal with terrorism. We have international treaties. We have a full section of the criminal code that deals with that, and a whole host of acts. The provisions of this bill would change the definition of special operations under the Access to Information Act, and as a result, confidential sources used by the government would now be considered special operational information or intelligence. As a result, there would be less transparency when it comes to information. Given the results of this government on the transparency file, this would do nothing but further the culture of secrecy and worry me more. To conclude, Mr. Speaker, I oppose this bill. We already have all the tools we need, tools that have proven effective, and we don't need these tools that have proven ineffective. There are freedoms and human rights that need to be taken into account, and this bill would violate those needlessly, i.e. the right to silence and the right to a fair trial. These are absolutely fundamental rights for Canadian society. The clauses we're discussing today were only invoked once and unsuccessfully, and I think that amply demonstrates the fact that we already have all the tools we need to fight terrorism effectively, so there's no reason to adopt provisions that would violate civil liberties. Mr. Speaker.
Questions and comments. Questions et commentaires. L'honorable député.
The Honourable Member for Brome-Missisquoi. Yes, hello. Good afternoon. I'd like to thank my colleague, and I have a question for her. I see that S-7 disturbs the balance between security and fundamental rights. I know you said we have the criminal code, we have international treaties. So abusive legislation like this, S-7, isn't the best way to strike the balance. What other means are available, in your opinion, i.e. policing, intelligence gathering? What other tools are there? The member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. As I said in my speech, as things currently stand, the criminal code and Canadian legislation amply meet the need to combat terrorism. The provisions in S-7 are not useful. I think that as things stand, police officers have the tools they need to take action, and as I said last Monday, we have to think, are we willing to sell our souls to the devil? Are we willing to accept provisions that would violate fundamental rights and just to give us a theoretical sense of greater security? We have to ask those questions. What's happening here goes too far. We shouldn't be sacrificing our rights to justify security needs which are basically pointless. Questions and comments? The Honourable Member for Abitibi, Bay James, Nunavik, EU. Thank you, Mr. Speaker. I'd like to congratulate my colleague from Abitibi-Témiscamingue on her presentation. I think the points she made were essential for this debate, including the points she made about international law and human rights. Having taken part in a number of debates internationally over 25 years, I'd like her to elaborate a bit more on those elements, human rights, and how this bill is going to affect all those issues. The Honourable Member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. When, for example, one definition has to do with arresting or detaining someone without trial, to my mind, that makes no sense. Absolutely none. the very basis of the legal systems of all great democracies in this world. You can't detain someone without trial, without telling them what they're being detained for. So I think right from there it seems wholly inappropriate. And that's why I ask people to not support this.
Questions et commentaires? Honorable député de Rosemont.
The honourable member for Rosemont-la-Petite-Patrie. Thank you very much, Mr. Speaker. I, too, would like to congratulate my NDP colleague on her very thoughtful, meaty speech with very legitimate concerns. But I'd like to ask a question about the general thrust of the Conservative government. Does this add to, is this not revealing of the Conservative approach? They're restricting civil liberties in order to get tough on crime. They're beefing up police powers. Are we not seeing a government that just wants to increasingly encroach on people's privacy? I don't know where the bill went. It disappeared off my desk, but it seems to me that systematically this government aims to limit freedoms, civil liberties, fundamental rights. So I'd like to know whether, in your view, we're seeing a general neoconservative thrust or direction coming from the government opposite. The honourable member. Thank you, Mr. Speaker. As I began my speech on Monday, I explained that this legislation all stems from a reaction, a fearful, panicked reaction to the events of 9/11. So it was understandable at the time. But what we see with this conservative trend is that they're continuing to sow fear, to fearmonger, to make people think that we're living in danger, when in fact we're not living in that much danger. They use the fear of terrorism to pass legislation that undermines fundamental rights of Canadians, and that is what's dangerous, Mr. Speaker.
For York South-Weston.
Thank you, Mr. Speaker. I appreciate my friend's comments about this bill, and one of the things I note is that the added powers given to the police have never been used, or have been used very rarely, but it does cost a lot of money. And I think, I might be wrong, that far more people were harmed by tainted meat in this country than were harmed by threats of terrorism as a result of there not being any bill in place from 2007 until today. And so we are spending our money unwisely, I believe, if we are not spending it on protecting Canadians from tainted meat, but we are spending it on imagined terrorism or on eliminating personal liberties in the guise of protection against terrorism. Would the member like to comment?
The honourable member for Abitibi-Temiskaming. Thank you very much, Mr. Speaker. That is indeed the case. As my colleague said, this bill is pointless. There's no measures in the bill that have ever proven effective or useful. They've never even been used. So clearly, when you know that those measures have never been used, we're wasting time in the House discussing that when we know there are people who've been infected by E. coli. It does indeed seem strange. Questions and comments? The honourable member for Châteauguay-Saint-Constant. Thank you, Mr. Speaker. I'd like to hear what my colleague has to say about the fact that could she explain the fact that the government is using the Senate increasingly to launch legislation? It's only to be expected that legislation should start here in the House, not in the Senate. This is a bill, it seems to me, that should have come from the Justice Minister, should have started in the House, but curiously, the government chooses to start with the Senate. What does my colleague think of that, using the Senate to introduce legislation? The honourable member for Abitibi-Temiskaming. Thank you very much, Mr. Speaker. I, too, find it very strange that the Senate's being used in this way. I think this is a bill that should have started off in the House of Commons. In fact, there's another bill coming, S-7, on food safety. I think we've discussed that issue at length, but once again, the bill starts in the Senate. It's completely incomprehensible to me. Why don't these bills start in the House of Commons? I don't know what planet they're living on, but it seems to me that it should have started in the House of Commons.
Questions and comments? Questions et commentaires? Reprise today.